I'm going to call to order the State of Rhode Island Coastal Resources Management Council Rights of Way Subcommittee meeting. To order, today is Tuesday, May 23, 2023. On our agenda, we have one matter. Prior to getting to that, I will ask Executive Director Willis for any staff reports, if there are any.
There are no staff reports tonight, Mr. Chair.
All right. Matter on our agenda is Spring Avenue Westerly status on submittal of agreed statement of facts and facts in dispute. And I will turn it over to Attorney DeSisto for any updates.
Well, on the matter at hand, I can tell you right now that there is no agreed statement of facts at this time, either facts agreed to or facts in dispute. However, we have Mr. Rubin here, who has in fact hasn't entered an appearance yet. He filed a motion. He has other motions pending. Before we get to the agreed statement of facts, and I have some suggestions for the subcommittee on that matter, I think we should hear from Mr. Rubin and one of the lawyers for the
Mr. Farside and Ms. Lansing.
Mr. Farside and Ms. Lansing. I'm sorry.
That's okay.
Mike?
Sure. Excuse me, just one moment here. Yeah, Mr. Chairman and council, Michael Rubin for Caroline Contrada. Actually, I did file a notice of appearance on behalf of Caroline Contrada. I also filed a motion to intervene on her behalf. Caroline Contrada is a concerned Westerly citizen, and she has made affidavit of her concerns, why she's concerned, and the fact that I'm her attorney. The motion to intervene is pending. I don't know how motions are actually objected to, heard, decided, and so forth. I don't know those mechanics, but obviously that would enable me to really reach an agreed statement of facts, as well as a statement of issues in dispute. Right now, and I'll let Mr. Farside speak for himself, obviously, but a letter has been written by him to the effect that until I'm actually formally a party, or until my client is, they wouldn't be able to actually finalize such an agreed statement. He did hold out the opportunity to negotiate over it in anticipation of such. So, that's been one holdup, sort of. I can't say it's a complete holdup or bar. Obviously, we've had to, bring Mr. Conley, representing the town, into the process. It's not Mr. Conley's fault at all. I was going to get to him a request for town documents that I might need, and that's on me. It's not on the town of Westerly. I just wanted to say that, or on Mr. Conley. We are working as expeditiously as we can to move it over, to move it along. We've lined up experts, especially a title expert. I'd rather not disclose the name at this time and place. There are some lay witnesses who I'd like to take the deposition of to preserve their testimony, not for discovery, but to perpetuate their testimony. There's like 3 such persons. They are either infirm or out of state or both. And I'm hoping for cooperation of Mr. Farside, representing the fire district, in getting an agreement regarding those depositions. I must say that, failing such an agreement, there is recourse in the statutes to the Superior Court to take a deposition in these circumstances, that it would be ancillary to a proceeding, a deposition to perpetuate testimony. There is a statute to that effect. I would hope to not have to resort to that with a miscellaneous petition, but if it came to that, then I would. But what all of this adds up to is having not even actually signed the agreement with our title expert, that's going to be signed within hours, literally. I don't see this matter, being necessarily ready in the time frame that you have mentioned. Once all is said and done. in terms of hammering that all out, possibly arranging depositions. I don't see Ms. Contrada through me being ready in that time frame. We're working to move it along as fast as possible. And with that, I'll take it.
What type of a time frame do you think?
I think I would say July at the earliest, and then we might be looking at the fall after that with vacation. But I would think that either I think it could be possible for July. I think it would be definitely in a position to go forward until then.
Okay. And that includes, the July target date would include an agreed statement of facts.
That's correct. I think, well, obviously it takes two to handle, but assuming we rolled up our sleeves, I think we could, do that in a late July timeframe. Yes.
Okay.
I'd also have to say, regardless, regarding the need to streamline this proceeding, which is something that you've emphasized very much, Councilor DeSisto, is, and I'm not faulting anybody for this, but the initial submission of the fire district was 167 pages. And I'm not, they're the ones who were kind of putting the case forward. They had more to submit. Our initial submission was 14 pages. Their follow-up submission was dozens of pages. I can't quite remember the exact number. Mine was 10 pages. So we're really trying to tread lightly here and not overload the council and to do a streamlined presentation at hearing. Thanks.
Okay, you have two other motions.
That's right. The motion to intervene is the most critical. I would renew the motion made a few months ago for the council to subpoena Mr. McCann, the head of the fire district. Although perhaps if we can roll up our sleeves and hammer out some stipulations, maybe that will prove unnecessary. I can't totally say. The other, which I think is of a little greater urgency, although not as urgent as the motion to intervene, is a motion that we made a few days after the last session that we met. And that's a motion to notify the Hoffman family of Connecticut, who are involved in this case under the name of a trust called Spray Rock Trust or Spray Rock Realty Trust. As was indicated in my motion, they are not only interested in the right of way, they're not only near the right of way, they are in the right of way. Now, when you say somebody encroaches on a right of way, you automatically think, oh, we need a surveyor. You need to go out and figure out what's what. In this case, the rare case you don't, because their location in the right of way is actually spelled out in a deed from the fire district's predecessor to that trust. And it says, you are in the right of way, and we hereby grant you, or purportedly grant you, the right to be in the right of way. And they're in the right of way with the split rail fence, stone wall, plantings, fencing, landscaping, etc. So, and as a matter of fact, the easement actually requires them to keep that stuff there. So, the Hoffman family of Hartford area in Connecticut is, I think, not an indispensable party, but a party that should be brought in if they can be. And I think that like a formal notice above, beyond, and more importantly, much sooner than you would typically give to an abutter should go out to the Hoffman family. I provided an address and I think a certified letter to them explaining the situation. And I'd be happy to help with drafting of that.
Would you agree that as this administrative body under the Administrative Procedures Act can adhere to the rules of evidence and the rules of civil procedure as they pertain in Superior Court? Would you agree with that statement?
Yes, pretty much. I am not. I wouldn't say that the council could not authorize a deposition. I wouldn't say that. For sure. I suppose based on Mr. Farside's letter, which I think you were.
I have it right in front of me.
Yeah. Obviously, the fire district, I'll let them speak for themselves, seems to not take that position. In which case perhaps going to the Superior Court, if it becomes necessary, would be, an excess, something that should be done under caution.
Yeah, well, I mean, it's the procedural issues always take precedent, these type of, the hearing we have now.
Right.
I got a final question for you. Do you agree that the subcommittee could accept affidavits of people with personal knowledge as probative evidence in this matter?
Well, you know better than I, and you know what it says about rules of evidence being, and you can quote it better than I, persuasive but not totally binding here. I would hate for us to get into a position where it's being reviewed by the Superior Court and ultimately by the Supreme Court, but the Supreme Court maybe took a different view than you and I might on that. And so out of prudence, I would want to do depositions. Also, I would anticipate video depositions, not lengthy. And, character does come across in a video deposition. When we're talking about, for instance, a 97-year-old, and I don't know if it's actually going to happen. Her health is precarious, but, I think that she has something to say to this council.
Okay,
Good.
so you have 3 pending motions. Mr. Forsythe, can we hear from you now?
Good evening, Mr. DeSisto. Good evening, council members. Joseph Forsythe for the Fire District. My colleague Alex Lancy. Pleasure to be here with you. Thank you, Mr. Rubin. I think a lot of what Mr. Rubin said resonates with us. Couple just housekeeping items. Our co-counsel Tom Liguori is still counsel in this matter with us, the Fire District. He's not present tonight. Perhaps he's on Zoom. Wanted to just note for the record that no one is here on behalf of the town. We have been in touch with Solicitor Conley. We're new to the appearing before the council on this matter, so I just wanted to know that in our first time meeting with Mr. Rubin, we don't view ourselves as being here in any hostile posture at all. We, to Mr. DeSisto's point, feel obligated to our client to ensure that we're following all of the process as closely as we can. And we are very open to working with Mr. Rubin and the town to the extent Mr. Rubin's motion to intervene as it's presently constituted or as it may be constituted in the future is granted. Working with him and the town to streamline this process as best we can. We're not looking to erect obstacles or call in elderly witnesses and so on. To that end, to your question, Mr. DeSisto, we've been working on an agreed upon statement of facts that pulls from a lot of the prior case filings. To the council's delight, it's currently only 7 pages long. We obviously, if Mr. Rubin's intervention is granted, we'll discuss it with him, but we plan to share that with Solicitor Conley shortly so that at least we can get the input from the town and from the Fire District incorporated into that document. Mr. Rubin mentioned witnesses and experts on the topic of process. We are going to need to receive the identities of those witnesses and or experts from Mr. Rubin in a timely fashion so that we can also interact with those individuals. And we've been talking with Mr. Rubin before this proceeding. We'll speak with him tomorrow or Thursday, probably at length about a lot of the procedural matters that are at play here. So it's a long way of saying we want to work with Mr. Rubin to the extent we can. We're going to work with the town. Our co-counsel, Mr. Liguori, welcome, Tom. So to that end, I just want the council to understand we want a streamlined process as well. On the issue of the motion to intervene, well, I guess let me back up and ask the council. We submitted a letter dated May 11th. I think that's the letter, Mr. DeSisto, you said you have in front of you. And the letter simply seeks to confirm that the council views this proceeding as involving the town as the petitioner and the Fire District as the respondent. Having received no response to the letter, can I receive an acknowledgement tonight that that is indeed the way this proceeding will move forward?
Well, now, and this is gonna, we're at a public meeting. And I'm just gonna let you know what my advice is gonna be, on the record. And that is, we really have to resolve the issue with Mr. Rubin. Now, you're asking, for time to interpose an objection, correct?
I'm asking for time to review his motion to intervene, which was only filed yesterday, to decide if we will object or not.
Well, I have to hold off in advising my clients on how the procedure is gonna go forward. I want to see what you're gonna do. Because it seems to me that the predicate question here, and it's gonna be, the advice to the board, they ultimately have the decision to make. But that's the predicate question, isn't it?
Well, I respectfully would like to inquire further on that, and Tom, I invite you to do so as well. The posture really is going to drive the posture of the parties involved is going to drive the proceeding. If the town is not the petitioner, then I guess we would want to know who the petitioner will be treated as. And I'm not sure what our view of Mr. Rubin's client's motion to intervene has on that sort of initial gating posture. Tom, do you think I misstated that question, or could you state it more artfully than I did?
We proceeded for some 2-year period with the understanding that the town was the petitioner and the fire district was the respondent. Have met. You developed the concept of the parties attempting to reach an agreed statement of facts and an agreement as to the exhibits. And I believe that's also what the petition to intervene represents, and argues that the town has not been forceful, in a sense, in terms of representing the claim that there is not a public right of way. So I think it would be a departure from how we proceeded for this period of time. That relative to the relationship of the town and the fire district were kept in line, then it would be, that doesn't, and I think all that Mr. Farside is saying is, if that's the case, then apply the intervener application as it would be when there's two adversaries and an applicant who's in another party who seeks to intervene, believing that it meets the criteria for doing so.
Understood. With the town as a petitioner, am I correct that they're asserting that this is a public right of way to the shore?
Asserting that there's a question as to whether there is, and sought the opinion of CRMC under its authority to make such a determination.
Mr. Rubin, the purpose for you intervening is to assert that this is a public right of way to the shore?
The purpose of Caroline Contrada intervening, that's my client.
I'm sorry.
That's fine. It was mentioned also before that, Mr. Rubin seeks to intervene. I just want to clear that up, but yes.
On behalf of his client.
Right. The town has referred the matter to the CRMC. The town has not taken a stand on whether or not it is a right of way. I would add that every step of the way, as you're all too well aware, give your copy of voluminous files on this. There's been a number of filings on this, and all along, every time I filed something, the town, or rather the fire district, I mean to say, has done me the honor of replying And vigorously so, even caught me in an error, I had to admit it. And I had to make a retraction of part of what I had submitted, so it's not as if the fire district was not aware of all this time that I was heavily involved. But, that said, there really haven't up to this point been any decisions, orders, or, all the process so far has been really more in the sense of a conference type process, not in terms of like the rigors of an actual hearing. So, I think I'm timely. Thank you, or my client is, I should say. Thanks.
I think that answers the question.
I'm sorry, Mr. DeSisto.
That answers the question. Mr. Rubin's client wants to intervene to preserve the rights of the public, which he will argue that this is a public right of way to the shore.
Well, I understand that's the purpose of their intervention, yes. And I'm really just narrowly focused on the process, and perhaps this is the better conversation that you, Mr. DeSisto, we and Mr. Rubin can have.
And Mr. Conley.
Thank you, and Mr. Conley, not at a public meeting to discuss, what we can do to streamline. At this point, we got a motion to intervene from his client yesterday, who we'd never heard of his client, and we need to review that information in order to advise our client whether to object or not. And we can have that decision. I think I indicated to you by a week from today. We can commit to doing it sooner, but do it by Friday and inform you of that decision.
Okay, and what about his other, and we'll get to the public in a second, but what about his other two motions? He wants to preserve some evidence.
This is the first time I'm hearing of it, and I'm happy to discuss that with him tomorrow, or if I've so indicated to Mr. Rubin. So I think it'd be premature to decide on that before we can talk about it.
Third thing is the notice to the Hoffmans.
I have no position on notice to the Hoffmans.
Okay. Does the committee need to hear anything else from any of the lawyers? I think it's appropriate to hear from any members of the public that want to speak, and then I'll give you some advice.
Okay.
Thank you very much.
Thank you.
Any public members come forward, sir?
Benjamin Weber, west of the Rhode Island. Thank you, Chair, Assistant Council, for the opportunity to speak. I just had to please allow me a little latitude here. I'm new to this kind of proceeding. As a matter of fact, that's one of my concerns, because I've done a lot of research, especially into CRMC guide for designation of rights of ways, and it seems as though this one kind of right off the get-go is not following any kind of precedent of procedure or protocol that I've seen before. So I'm just maybe a little explanation for the public as to how this is going to go down, because I'm sitting over here and I'm hearing a lot of terms like motions and intervene and parties, and it seems to me like we're in a court of law already. And if that be the case, then I would have to say there's one party that's not been represented and is not represented yet, and that is the general public. Who's representing the general public in this matter? That would be the first and foremost question I have. Does the general public file an appearance? Does the general public need to provide you with a statement of facts, disputed or otherwise? Because I just want to give this council and the attorneys that are present a little background as to how this came about and we're even here tonight. It was the general public that demanded the previous town council to send Spring Avenue right away to CRMC for possible designation and review. The general public on its own did an enormous amount of research and work to provide evidence, the initial filings in this case. Started off with two theories. Incipient dedication claim and a statutory claim. As far as I know, that's where we're at, but I just heard one thing that honestly, me representing now here, the public, was a little bit concerned about. I don't think we should be having meetings not public. Every single meeting that we have on this case should be public. That's what we're here for. That's what it was sent to you for public hearings, so the public can provide more evidence, of which we have over the last 3 years gathered to support the claims of incipient dedication or otherwise. So out of abundance of caution, I just wanted to remind the council why we're here and how we got here. And again, the question needs to be answered. Who's representing the general public? Is the Attorney General? Is the counsel for CRMC? It just seems like a battle of lawyers right now. So we need to know if we need to make an appearance, I guess, and who that would be. Thank you.
Yeah, actually, I do. It's a couple of points, Mr. Weber. The first one is the public has standing in and of itself. You don't have to enter an appearance. The process by statute is that if there is a request to designate a right of way to the shore, that it's a public hearing process. So a public hearing will have to be held by the subcommittee in Westerly to give the public an opportunity to speak on this and to present their own evidence. Mr. Rubin is representing some members of the public, and they wanted, rather than just them coming in, they would have him do it. He's actually put a lot of work into this. And also, he's concerned that there are some members of the public that may not be able to attend the public hearing. That's one of his motions.
Absolutely.
So that puts him, what he's doing on it, on the side. And actually, he'll be representing members of the public, not the entire public, but members of the public. Do you have standing? Yes, you do. Will you be able to speak and present evidence? Yes, you will. Now, I will say this in defense of the Attorney General. He did send a letter to the executive director, and I'm not going to go over it because it's a lengthy letter. But the last part of the last paragraph from his letter, and it's a public document. Public access to Rhode Island's coastal waterfront resources is a priority mission of the Attorney General, who, like the CRMC, is empowered to protect the public's rights and interests in accessing our state's coastal resources. There is strong, uncontradicted evidence for the CRMC right-of-way subcommittee to determine that Spring Avenue is a public right-of-way to the shore. An official CRMC designation would secure the public's right to access and enjoy this waterfront access point permanently and empower the Attorney General to defend it. It is time to ensure Spring Avenue is permanently and forever public and free of the private encroachments that have unlawfully hindered access to the shore in recent decades. I only put that into you just to let you know that the Attorney General has had contact with Coastal on this, has an interest in this, and may well take a more formal position in the future. So I hope that answers your question.
Absolutely. Thank you.
As Mr. Lang said.
Hello, Richard Langsa, Budlong Farm Road in Warwick. And I really appreciate the fire district showing up tonight. I think that's great. The main concern I had with the discussion was somehow carving this town of Westerly to the side and presenting them as the petitioner, and then maybe attempting to discredit them as a petitioner. That was the process discussion that I heard a little bit. And of course, the CRMC Rights of Way Committee is way beyond that. When a member of the public comes before the Rights of Way Committee, that's when the hearing begins. And if a party such as a town falls by the wayside, that should not negate the hearing. The hearing should go ahead because members of the public were the ones who brought the petition in even before the town of Westerly was involved. So that if somehow the town of Westerly decides it doesn't want to be involved or whatever, the hearing should continue, in my opinion. And I'd just like to have that noted. The other thing is regarding the Hoffmans. My family has known the Hoffmans for 40, 50 years, maybe. I grew up in Norwich, but I moved to the Hartford area as a young adult, and my wife her uncle happened to be a major player. So I do know the family, and I think it's very important to bring them in, especially if the committee finds that there might be an abandonment of the Spring Avenue extension. And in the case of an abandonment on the common law, and perhaps by statute too, the abutters own to the center of the abandonment. So in that case, if we were to do that, then obviously the Hoffmans are more than just an interested party, as some of the deeds suggest that they are actually owners. As is the fire district on the other side. The fire district, of course, would own to the center on the east, and the Hoffmans would own to the center on the left, on the west. So I think it's really important to bring these people in. And I do appreciate everything you're doing, and I have a feeling that this is going to be more of a September issue, because August is just a very difficult time for everybody. And July is not much better. But I appreciate your time and your and my ability to speak to you as you. Thank you very much.
You're welcome. Anyone else from the public? Come forward, sir.
Good evening, Anthony Palazzolo. I'd like to start with my standard disclaimer. I think the last time I did that, I maybe raised some concern with Mr. DeSisto. I assure you, I do it everywhere I go, so everybody understands that I'm not a Rhode Island attorney. I am licensed in California and in Connecticut. I don't represent anybody in Rhode Island matters. I don't have any clients here. I never took a penny in any of my rights of way work. Just want to make sure everybody understands that. I share a lot of concerns that Ben Weber raised a few moments ago. And I don't know how unusual it is with rights of ways that you have worked on in the past, but I was present 2.5 years ago when there was general public outcry over Spring Avenue down in Westerly. And I can tell you from my experience of being involved in it, witnessing it, that there would be a Spring Avenue investigation for that outcry by the general public. In my opinion, the town council was very reluctant to take any action whatsoever. Bill Conley, the attorney for the town of Westerly, advised them on 2 occasions that there's no basis whatsoever for a public right of way on Spring Avenue. And then his associate took a 3rd opportunity to say essentially the same thing. The first time Bill Conley weighed in on the matter, he said he reviewed a title opinion that was prepared by Charlie Solovicek. In my opinion, mischaracterized it by saying, "Oh, he determined there was no town road there whatsoever." And then he said something really interesting. He said, "And no one has brought to my attention any evidence to the contrary." I took that to mean he didn't lift a finger, find any facts, or look at any new law that might determine that there was a right of way. None whatsoever. The second time he addressed it was at a town council meeting. And that time, he said something quite different. He told the council that he had considered all relevant facts and all legal theories, and he had determined that there was no grounds on which to find a right of way here. That, in my opinion, starkly contradicts what he told the council previously. And so, the substance here is concerning enough. The fact that, in my opinion, he grossly contradicted himself is of additional concern. In fact, it was in part in response to Bill Conley's mishandling of this matter that a number of members of the public worked on and eventually produced the pictorial timeline for Spring Avenue, which it seems was the trigger for the town council to refer this matter up here. And I believe that that is being taken seriously at CRMC, and I thank you for that. But the first point I want to make here is that I don't know how often this happens with you, but it seems to me that in this particular occasion, the public is in a special role in that basically had a really hard time getting the town establishment to do anything. Therefore, the public stepped in and did that which we thought the town should be doing. Now, I thank Mike Rubin for stepping in and bearing some of that burden. But I want to also emphasize as a second point that the public has continued to try to advance this right of way by doing things like interacting with Michael Rubin. I myself have provided him with substantial information beyond that which I filed with CRMC, and just today I gave him the names of a number of witnesses that I hope will be helpful. So, I do thank Mr. Rubin for coming forward, although he does have one client and not the public writ large. And we're doing what we can to work with him, and I think there's a substantial amount of things that are occurring in the background that you don't know about because our time is short here. With that in mind, Mike has obviously filed 3 motions. I'm sure you're going to take them seriously, and I just wanted to sort of bear witness that Mike has been working on these for some time now. And we've been trying to support him in that effort. So although these things just came in, I hope that you'll find the time to address them quickly. I'd also like to speak specifically to Mr. DeSisto's question to Mike Rubin regarding whether, and please correct me if I mischaracterize your question. It was roughly whether you think the subcommittee should be following the rules of the Superior Court on evidentiary matters. Keep saying I'm no Rhode Island attorney, but I've looked at many rights of way proceedings that were available online, and I've read through the normal, what I believe is the normal procedures for these hearings. And I would like to say that I would object to strict adherence to the rules of evidence from the Superior Court. It's my understanding that in normal rights of way proceedings, that evidentiary matters have a much more relaxed standard. And it seems to me that that was not by accident. It seemed like that was the established rule, specifically because of things like these rights of way matters can stretch back over a century. And so, finding recipient witnesses who are over 100 years old can be difficult. And for these kinds of reasons, I would ask that you follow the normal rules, the relaxed rules of evidence and procedure normally associated with rights of way subcommittee hearings. So thank you very much for your time.
Thank you. Anyone else wish to speak? Okay,
All right, I have a few things to say.
all right.
The first one is directly to what Mr. Weber had to say. And even a little bit, Mr. Palazzolo. Is this an unusual one? Yes. This originally came to CRMC from a request from the town, basically saying, make a determination on this rather than a petition to say it is. That's the first thing. The second thing is I can tell you that from my experience, which is not nearly as long as my predecessor in the position, that I've received more documentation on this right of way than any other. Even Mr. Langsess one in Buttonwoods, and he's close. So there is a lot of things here. One of the reasons I asked the questions earlier was because you have lawyers involved in this. And one of the concerns that I think the committee shares is that, we want to make sure that how this goes forward, there are no procedural defects, which would give rise to an appeal afterwards and string things out even more. So I think one of the goals that we've discussed at these meetings previously, it's been my advice, is to make sure that procedurally everything is done properly on this, so that in the event that there is an appeal, there's no procedural issues, and it would just get down to the merits of what we have to do here. So that's the first thing. That's the final thing. I'm going to advise you to hold on the two motions, the first two motions that Mr. Rubin has. Give the fire district an opportunity to object if they do. The first one is whether or not he can intervene. The second one is the motion to preserve evidence by way of depositions. On that, it seems to me that the second one is tied to whether or not you grant the first. The third one aligns with what the procedures are anyway, and the practice of coastal in notifying those parties that are direct abutters. In this case, is an allegation that they might actually have property in the right of way. So I think that's appropriate. There's no objection to that. That motion can be granted. Mike will have Lisa put the Hoffmans in. I don't think we need any help with any notice to them. And we'll send that out. And Lisa's very good about including them on any emails that might go out. I'm assuming that this can be handled at the next meeting if there's an objection, so that we can have one just specifically on that. I'm going to give a final piece of advice, and I think that can be taken up at the next meeting, depending on how these motions go. This agreed statement of facts is designed to streamline the process, not string it out. So if it appears as though there's going to either be objections to the agreed statement of facts, or it appears that that's not something that's going to happen, or it's going to take too long, I would convert my advice to say, give a written statement of facts, and then just go ahead and schedule a hearing so we can get going on this thing. So that's my advice at this time. If you have any questions, be happy to answer them.
Any questions? Tricia or Ron? Tony? So agreeing with your advice, just put now for another date.
Continue the motions 1 and 2, intervene and preserve evidence
Number
to the
3.
next meeting. And 3, I think you can grant the motion. And that's notice to the Hoffmans.
Need a formal motion?
I do, yes.
This one, so would the next meeting be the same day as the July CRMC meeting, or?
It would be,
I'm away in Dubai, that's fine.
the next Rights of Way Subcommittee meeting would be the 4th Tuesday in June.
Okay, that's good.
If I could just add housekeeping matter, the actual name of the landowner is not the Hoffmans, it's the name of a trust for the Spray Rock Trust. Apparently there's 2 trusts as part of that help in the land records, but we don't have an email address for them other than my informal looking for Google searches and so forth for the principals. All we have is the tax assessor's address for those trusts, which is a post office box. But I'll help.
You mentioned the Spray Rock Trust, and I'm sorry I used the shorthand for the family name.
Right,
But assuming that you can supply that information,
I can.
we'll send that out and we'll request it, any email or other type of social media addresses.
Right.
Which somebody else is going to have to handle because I have difficulty with that.
Yeah.
So we need a motion from the subcommittee to grant that.
Correct, yes.
I'll make the motion that we accept, whether we grant the notification of direct abutters to the Spray Rock Realty Trust.
Correct. Continue, and that also includes continuing the other two motions to your next meeting.
And continuing to next week. Okay,
Motion made, is there a second?
Second,
Motion made a second, any discussion, hearing none? I'll poll Mr. Gagnon,
I,
Ms. Reynolds.
aye.
And to Raymond Poyer, vote aye. Anything else to do for us? Entertain a motion to adjourn the rights of way subcommittee.
So moved.
second,
Motion made a second, all in favor?
I.
Aye,
Aye.
subcommittee is adjourned. Thank you.
Thank you.